Then we'll get going. All right, good evening, everybody. We'll call the meeting to order at 5:03. Doug, if you can just note the roll call and item 3, our minutes. We have none for this meeting. And so we'll move on to item 4, which is a consideration and action on the approval of a written decision and an order in the case number Z1 2025. And this is pursuant to City Code 175-12A, George Kinsler and Ramona Rohr at 4539 Winnequa Road. And they're appealing the decisions of the city's building inspector dated January 3rd, 2025 and January 13th, 2025, denying the building permits requested to repair, replace, remediate, replace, and remodel existing improvements and remove first and second floor above floor deck and foundation, maintain masonry fireplace. Case number Z1 2025. And Doug or our attorney, are you able to provide just an intro? And then I believe we're looking for a motion on the action.
At the last meeting, the board made a motion and took a vote to deny the appeal. What I've done with the draft decision that you've got in front of you is tried as best I could to explain the rationale that I heard while the discussion was going on as the purpose for your decision. I want to emphasize that it is your decision. It was your vote, and this is not anything that you see on this paper that doesn't meet with your intent with that motion. We should change because I'm not here to make the decision, just to try to reflect what your decision was. Before you get into discussion on the draft that I provided, I do want to let you know that Doug and I received an email today from Attorney Fleming asking, basically saying that he's not going to be able to make it tonight, but did ask a sentence be added to the decision at the end, which would read as follows. Appellants may, however, construct an entirely new structure within the footprint of the existing structure as shown in the survey by Williamson Surveying and Associates dated April 17, 2024, LLC, not sure what that means, and on file with the Dane County surveyor without obtaining variance pursuant to section 480.-40A of the City of Manoa Code of Ordinances. So essentially, he's asking for an affirmative statement by this board that the applicant does have the right to build a house on the same footprint. Attorney Tierney then responded saying that she, I'll say, strenuously objects to including that language. As she said, it's contrary to the board's decision. My recommendation would be not to include that because I think it's beyond the scope of the appeal first, in that the question on appeal was whether he was entitled to those permits that were denied, not whether he's entitled to some future permit that you haven't seen yet. The second reason I would recommend against it is that the way it's worded, it seems to suggest that he doesn't have to do anything more in order to go build another house. We know he needs to submit a building permit application. That building permit application has to meet code. And I think that you don't want to be in a position of saying, yeah, go ahead and build when you don't have all that information in front of you. I guess the third reason I would add is that you are an appellate body. You're not an administrative permit issuing body. So the determination of whether or not a new permit should be issued would first come from the building inspector and then be appealed to you if in fact there's a disagreement on that application.
That sounds all reasonable and fits with what I was thinking as well. I'll open it up for any discussion.
Am I muted? No, okay. I would agree with that. I think one, it's beyond the scope of the application. We can't rule on a plan that we haven't seen and one that hasn't been appealed. I think it's also against the intent of our decision as the board. we were really there to decide the two narrow scopes that is outlined in the decision and order. And is fairly consistent with my notes and recollection from that meeting. And I don't think I don't think we should be ruling on anything or making a decision on any plans that we haven't seen and haven't had to go through the regular process of being approved by the city and with the building inspector and submitting of a site plan before we make that decision. Those are just my 2 cents.
Yeah, wholeheartedly agree with you both.
Beth?
Oh, I absolutely agree. I don't think you can bind a future board.
All right, is there any questions or concerns or edits for the drafted decision in order?
The only proposal that I would make would be, if memory serves from the discussion we had, that the building inspector on the second reason, I thought the first reason was perfectly on point. The second reason was also related to a particular citation within the code of the city of Monona, that if there's an existing city order related to the property, that's why he denied. If I don't know if anyone else remembers that, but to me, I would include that as well, because at the end of the day, the second question on the appeal was, was that building inspector denying their permit because of the existing city order to raise the property correct? And we all affirmed that it was, basically, or denied their appeal. And so just including that reference to whatever code it was that the building inspector referenced, I thought would be beneficial.
Brad or Beth, do you have any comments regarding that piece?
I thought he was referencing the court order.
Yeah, give me one. Let me see if I can find it really fast. And if not, like I'm more than comfortable with the way that this is framed, so this does not need to walk things down.
Looking for his letter.
No, I'm
Yeah.
looking for a code. Yes, thank you. So that's really helpful, Beth. Thank you. Yeah, so the building inspector denied on January 13 the application because it does not comport with the order, but it was pursuant to Monona Ordinance 175-8E. 75. I don't know. I can't find it on my phone that quickly, I guess, but I just thought it would be helpful to include a reference to that to say basically like they were asking us to overturn that decision, and it was a very clearly correct decision based on the ordinance, which was, my memory was that he shall deny if there's an existing city order related to the property.
Doug, are you able to, oh, sorry, Doug, are you able to find 8E?
I can pull that up now.
Okay.
It was 175-8E. Are we talking about
Yeah, that's what it looks like from the letter.
I think it's issuance of permits. If the building inspector finds that the proposed building will comply with all ordinances of the city and all laws and lawful orders of the state, he or she shall officially approve the same and shall issue a building permit therefore, which shall be kept at the site of the proposed building. If adequate plans are presented to the building inspector, he or she may at his or her discretion issue a permit for part of the building before receiving the plans and specifications for the entire building, but work on any building shall not be commenced until a permit or waiver of plans has been issued. I think that's the code. I think that's the one
Yep.
it's correctly cited, because I think
Yep.
the discussion was about lawful orders, the lawful orders portion of that. All lawful laws and lawful orders of the state,
Right.
and whether or not they're complying with those. And I think the other piece of that that may fall into that is whether or not adequate plans are presented to the building inspector. And I think grounds one
I know.
is the lack of adequate plans, and
Yeah.
number two, there was discussion, and part of the discussion and part of the decision was that the raise order was a lawful order.
Right, yeah, so that, you're exactly on point, Brad, thank you for bringing that up. I would just remember that conversation with the building inspector. He denied the second one because there was a lawful existing state order on the property, and the building plans that were proposed did not comport with that order, which necessitated raising the property. And the plans that were presented didn't. So I just thought it would be helpful to include that particular reference, since that's, to me, is what the decision turned on a little bit, is that was a perfectly appropriate reason to reject the application, and we didn't overturn that.
Sure, I think that's correct, like adding a line that,
Can you put it after upheld on appeal, see also, and then cite the code?
I would do it. It's a second reason cited by the building inspector for denial of the permits was the existence of a court order determining the status of the property vis-a-vis the raise order. The building inspector determined that was a valid state order, and the plans did not comport with that pursuant to section 175-8E or whatever. That's where I would throw it. But
yeah, the board can, and like the board agreed that a lawful raise order existed
and was a valid reason for
denying.
denial of the, yeah.
Doug, I'm guessing you need that as a part of the motion to include adopting this decision and order with that edit.
Believe that would be part of the amendment, is that correct?
Yeah, I think we should first get the exact language down that we're gonna
Yeah.
add to the decision. And then I'll read it back, and that can be a motion to amend the, but we don't have a motion yet to approve the decision. You can then make a single motion to approve it as we revised it.
Okay, and so Jesse, since you're there in person, do you want to? Are you able to kind of restate what we just did with the connection that Brad included?
Yeah.
And that way that we can capture it, and then if we capture it as a motion to adopt the decision in order with the following language included.
So motion to approve the decision with the following language included as, somewhere within the paragraph beginning, the second reason cited by the building inspector. And we would include the language.
Call it a new second sentence.
New second sentence. Language to be included would be, the building inspector indicated the denial of the application was due to the existence of a lawful state order to raise the property, and denial pursuant to section 175-8E. And then the board agreed that the state order was valid, and thus the building inspector's denial was appropriate. Something along those
All right.
lines.
Is there a
Is
second?
that close enough, Brad?
I would just add the word also denied. Because
Yeah.
the first, for another reason denied was the insufficiency of the application itself.
Yeah.
All right, with that little friendly adjustment, we have a motion on the table, and Brad, am I hearing that you would be a second?
Yeah, I would second, but I also just want to confirm there's no other adjustments to the decision in order that
Did
are
not have
needed.
any.
You put the exact language down. You're writing faster than I was
I
typing.
didn't catch it. I got close.
You're gonna have to make some tweaks anyway.
Building inspector indicated the applications were also denied because the.
Of an existing lawful state order. To raise the property. Thus, the building inspector's denial was appropriate pursuant to 175-8E. Period, the board. Or what would you say, and due to the insufficiency of the plans. Period, the board. Agreed that the denial was appropriate. Can't remember, something along those lines.
175-8E.
Right?
Yep.
Yeah.
While he's writing that out for one final read of it before we have a vote, is there any additional edits that people believe need to be included?
Yes, one thing is, we've got two different reasons. So with the 175-8E, I wouldn't combine it with the insufficiency because that's up here. Unless you're gonna conclude it at the end. Does that make sense?
I really am fine either way. Yeah, I understand what you're saying, but. Brad, she's just saying that like kind of part one, there's sort of two parts,
Right.
part one, or yeah, okay,
Yeah,
that's fine with me.
Okay, here's what I have so far. You were talking fast as
I know, I always do.
Building inspector indicated that the applications were also denied because of an existing lawful state order to raise the property. Thus, the denial was appropriate pursuant to section 175-8E of the code. The board agrees that the court order was a lawful state order and.
Thus, the denial was appropriate. Something like that.
Good catch.
Beth, the way it's written now, does that concur with what you're making a comment about?
Yeah.
Okay.
Mhm.
All right, do we need a final read of that? But we have a motion and we have a second. It sounds like we have it all buttoned up.
Good to me.
I think so.
All right, any further discussion? Hearing none. All those in favor of the decision and order as amended or as edited, say aye.
Aye.
Opposed? All right, the decision order has been approved. And Doug, you need me to come by to sign it?
Yes, we can coordinate once we stop the recording, but I'll work with you to get that done.
Do we need
Okay.
a formal motion to deny the Attorney Fleming's request for the additional language?
No.
No, okay.
You're good.
Right, so item 4 is done. Item 5, we can do A, B, and C together. Doug, anything that you want to note to the group? Because we've already talked about upcoming meetings.
Nothing to add.
Okay. All right, we need a motion for adjournment, number 6.
I so move.
I'll second.
All right, all those in favor say aye.
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 Opposed? All right, thank you, everybody.